Hello everyone, my name is Praveen Mishra and I welcome you all to StudyIQ IS English, and here we are going to discuss about the very important question related to our Constitution Article 14. Is Article 31 capital C, that is also part of our fundamental rights, is bigger than the provisions of Article 14, that is equality before law? Means, like, are we saying that there is an article that can subserve or that can submerge the provisions of Article 14 itself, that is equality before law or the equal protection of laws? Well, let's discuss with the help of a judgment, with the help of the case that is named as Sanjeev Coke Manufacturing Company versus Bharat Cooking Coal Limited, the case that happened actually in the year 1983. And basically, the demand of the petitioner, it was just with regard to the act known as the Nationalization of Coke Oven Plants under the Cooking Coal Mines Nationalization Act of 1972. Basically, the petitioner argued that this particular law, this particular nationalization of the coal mines or even the coke oven plants, is violating his fundamental rights guaranteed under Article 14, that is equality before law, as well as under Article 19, Clause 1, Subclause G, basically the right to have your own occupation or profession, business of your own choice. So freedom to choose up any occupation, business, service, etc. So the petitioners, they argued that this particular segment, it is actually violating their fundamental rights under Article 14 as well as 19 Clause 1 Subclause G. As well as the case addressed the constitutional challenges to the nationalization of the private property, especially focusing on the interpretation of Article 39 Clause B as well as Article 31 capital C. Article 31 capital C, what it is, let's discuss first about. As we know, as per the provisions of the Constitution, there are two parts, Part 3 and Part 4. So Part 3, that is fundamental rights. Part 4, that is directive principles of state policy. Fundamental rights, they are absolutely enforceable in nature. That is, they are bound to be followed, bound to be implemented. Whereas directive principles of state policies, they are non-justiciable or non-enforceable in nature. As in, they are voluntary things. If applied, well and good. If doesn't, no matter. Okay. So there are two directive principles of state policies guaranteed under Article 39 Clause B and Clause C, right, that can be implemented forcefully, that is through the force of law, and that is mentioned under Article 31 capital C. So basically, Article 31 capital C gives enforceable or justiciable nature to two clauses of Article 39, that is Clause B and Clause C. Simply, the first one, that is Clause B, talks about equal distribution of resources, whereas Clause C talks about no concentration of wealth. So remember, guys, DPSPs, they are non-enforceable in nature, but Article 39 Clause B and Clause C could be made enforceable in nature as per Article 31 capital C. Okay, this thing which was added through the 25th Constitutional Amendment Act. Okay, remember this thing, it was added through what? Article 31 capital C through the 25th Constitutional Amendment Act. Okay, and now the legal questions in front of the Supreme Court with regard to the very same case, that is the Sanjeev Coke manufacturing case, right? So does nationalization violate the fundamental rights under Article 14 and 19? First thing. And second question, whether Article 31 capital C of the Constitution of India can be used to shield the nationalization laws from any kind of judicial review, as it was a thing in trend at that time, that, the parliament was making such laws or legislations, those who were considered as free or immune from any kind of judicial review. So these two legal questions were there in front of the Supreme Court. And now, the course of the case. The case actually arose from the nationalization of coking coal mines and coke oven plants under a series of legislative acts that happened between 1971 and 1973. Namely, here are the three acts, as you can see: Coking Coal Mines Emergency Provisions Act of 1971, Coking Coal Mines Nationalization Act of 1972, and Coking Coal Mines Taking Over of Management Act 1973. So these three particular legislations, there were many coal plants or coke oven plants that were private and that were taken by the government in the sake or in the name of nationalization, right? So the petitioner challenged the inclusion of their coke oven plants as violative to their fundamental rights guaranteed under Article 14, that is equality before law, as well as Article 19, Clause 1, Subclause G, right? Now, further to the case, the key facts. Constitutional validity of nationalization. The question one, the very first question, whether the inclusion of the petitioner's coke oven plants, okay, was violating their Article 14 or not. Secondly, whether the nationalization was protected Article 31 capital C, which shields actually Article 39 clause B along with Article 39 clause C. Then, interpretation of Article 39 clause B. Whether the term material resources of the community under Article 39 clause B includes privately owned resources such as the coke oven plants or anything. And finally, the scope or the basically the coverage of Article 31 capital C, how much wide it is. So whether Article 31 capital C provided immunity to the nationalization laws from the judicial review under Article 14 and 19 as long as it aimed to achieve the objectives of Article 39 clause B and C. Right, so these were basically the questions in front of the judiciary. And now let's talk about the judgment. What Supreme Court stated that yes, the nationalization laws are absolutely valid, and further it imposed the fine of rupees 10,000 rupees each on all the petitioners. Basically 2 petitioners were involved. So a 5-judge constitution bench led by Justice O. Chinnappa Reddy, okay, give this judgment that yes, the nationalization laws, they're absolutely valid and they do not violate the provisions of Article 14, Article 19, Clause 1, Subclause G, as well as Article 31, capital C. Literally covers the nationalization laws in our country, but yes, obviously, it's not immune from any kind of judicial review. So Supreme Court took the reference from a previous case that held in the year 1978 that is named as Krishnan Iyer. Okay, Justice Krishnan Iyer was the judge. The name of the case is State of Kerala versus Ranganatha Reddy 1978, holding that material resources of the community that is mentioned under Article 39 clause B and C is not just for public, it's also of privately owned resources, privately owned land, assets, whatever. So in the very same way, zamindari system was abolished. That means that is the lands, they used to be the private property of the zamindars or the landholders, right? So the zameens or the lands, they were taken or confiscated by the government through the abolition of the Zamindar Acts and so on, right? So these kinds of legislations were there into the trend at that time. And so the lands were taken, confiscated and was distributed among the public, among the masses, specifically between the farmers and the peasants. So here it is the same concern, that is the material resources that is mentioned under Article 39 clause B and C includes both public as well as privately owned assets or resources. Further, the court emphasized that the resources like cooking coal, essential for the industrial development, it fall within the ambit of Article 39 clause B, justifying their nationalization to serve the common goal. And the term distribute under Article 39 clause B, same, was interpreted broadly to include not just the retail distribution, but also the allocation of resources across the regions, industries, as well as sectors to promote the equitable and sustainable development on the same side as well. So guys, remember, the interpretation of Article 31 capital C was widened. That yes, if any law that is made for the sake of nationalization of any asset, and the aim of the nationalization is just to achieve the principles of Article 39 clause B, that is simply talking about the equal distribution of material resources, whether public or private, it shall be stand valid. It shall be standing valid, any such law, even if it violates Article 14. And hence the judgment came in that whenever Article 31 capital C comes in, Article 14 goes out. So whenever it will be the condition that we have to implement any law that is violating Article 14, but it is from the perspective of implementation of equality of resources, that is basically following the principles of socialism as enshrined in our constitution, then that particular law, even if it is violating Article 14, will stand valid in the eyes of the law in the courtroom, okay, of this nation. So it is stated whenever Article 31 capital C comes in, Article 14 goes out, right? So this is where the judgment finally came in, and through which case it is Sanjeev Coke Manufacturing versus Bharat Coking Coal Limited, 1983. I hope this is all clear, guys. And if you have any confusion, any doubt, please do let us know into the comment section. And apart from that, to all the serious UPSC aspirants, we have got for you the optional carnival. The optional fest is live. Remember this thing. So if you are having your target year as 2026 and you are right now here looking forward for your optional classes, so here it's the right time. So what we have got for you, the GSP2I Foundation batch along with your optionals. Okay, so 1000 plus hours of live classes along with the access to the recorded lectures taught by the greatest educators of this time, right? From Shashank Tyagi to Bhuvan Jha sir, from Prashant Tiwari sir to Alok Ojha sir, right? From Chandan Sharma to we have got Ankit Singh sir to Ankit Agarwal sir. We have got, many wonderful names for you, and those guys are there to teach you in our resolution batches. And yes, whatever your optional is, political science and international relations, public administration, history, geography, economics, public administration, philosophy, sociology, agriculture, okay, whatever, English literature, Hindi literature, we have got you covered, right? So remember, guys, the optional fest is ending by tomorrow, that is by 24th of July only. And what you need is just a promo code with yourself before enrolling into the StudyIQ courses so that you get the maximum possible discount. And here is the promo code for you, that is PRV Live. So right now, your course fee, the subscription plan, whatever you are going to purchase, okay, you will get the maximum discount with this promo code PRV Live, and the price that you need to pay right now here is along with your optional, that is 42,999 only, because that shall also include the class notes that is converted into the PDF format and then given to you immediately after the end of the session. Along with that, all the printed books, that is, the reading material will be sent to you. 18 sets of printed books will be sent to you at your doorstep. You don't have to go anywhere to collect it. Well, I think that's not enough. Let's make it enough. Does this one subscription covers the test series as well? Yes, it does. Prelims, 75 plus tests. Mains, 15 plus tests. And multiple mock interviews for your interview. That is, it is also going to include the interview guidance program. So guys, everything under just one single subscription, right? So that is known as the resolution subscription. What you need is just a promo code, that is PRV Live. So guys, please keep the promo code with yourself, keep it copied with you, okay? And you can avail maximum possible discount using this promo code while purchasing any subscription on our StudyIQ platform. So guys, remember, along with the optional fest, our GS Foundation batch is also about to commence from 25th of July. So guys, please remember, if you have enrolled, congratulations, you have marked the very first step in your journey. And if you haven't, so guys, quickly take up the journey, take up the step at the earliest possible time, as the clock is ticking very fast. So 25th of July, our batches are going to commence. Okay, so guys, please remember, we have got multiple subscription plans for you. Like for example, we have got the gold, we have got the platinum, we have got the diamond subscription plans, and the prices are starting with just rupees 9,999 only. For different subscriptions, we have got different prices. This is what the starting price is. And once again, the promo code remains the same. And in case you wish to connect with me, we can connect on our Telegram channel as well as Instagram channel here. Okay, so for Instagram, you can connect me with the username that is Praveen Mishra _2107. And Telegram, the very same promo code, that is PRV Live. And here is also the QR code. You can just scan and connect with me on my Telegram channel. Here I share all the class notes, PDFs, links, and everything. But before you guys leave, please don't forget to hit the subscribe button of our StudyIQ IS English channel. You know it very well. Channel dedicated, committed with just one single motto, with just one single agenda to provide you quality and quantity of the content. So guys, please hit the subscribe button and never miss an update from the channel. See you soon. Bye bye. Good day. Take care. Jai Hind. Jai Bharat.